Good morning, everybody. Happy Tuesday. Hope everybody's doing well, and we're excited about what's going on in the market. I know there's a lot of stuff going on right now, and we've had a lot of conversations about what the market conditions are and what the way things are going, and I think a lot of the media that is out there is, similar to what we've been dealing with the last couple of years. Is I think there's a feeling or kind of an untruth on certain things, where what I'm bringing up is we looked at some recent stats in the marketplace, and one thing that is good for our market is that we are finally getting an inventory of listings again, where 3-4 months ago, 2 or 3 months ago, we probably had, it was around 1,000 listings that were maybe like in Salt Lake. Now we've got over 7,000 listings, which is extremely good, because we are now not having to panic. Our buyers are no longer having to panic, or at least panic as much as they were, which was also driving up prices. But another number to compare against is this time last year, the number of transactions that were still pending, we've only dropped off by, it's about a 10% drop off on the number of pending transactions from last year to this year. So what's great about that is we are seeing an increase in inventory, but we're also continuing to see transactions closing. So I think that's one message that is not being delivered out there. So I say that to you today, just that you guys can take a breath and recognize that, you know what, hey, things are not as bad as what everyone is saying. We're not even close. Things that I keep sharing this example with everybody, when it seems like a common statement that says, things are slowed down. Well, okay, that might be a fair statement. But when you were going 500 miles an hour and you slow down to 300 miles an hour, you're still going 300 miles an hour. So when we hear certain things, we need to make sure that we are also looking at the information and not just relying upon the opinions, the negative opinions of the information we're hearing. So there's my little soapbox right out of the gate.
Can I add something?
Please do, Jeanette.
I've been working with a buyer for the last week, and we have been in so many multiple offer situations. I can't believe it. So to think that that isn't still happening, it is. It's just different. You're not necessarily offering a lot, have to offer over the list, but there's other things. And the multiple offers, we finally got under contract after writing about 6 offers, because we were in multiple offer situations on every one of them.
And thanks, Jeanette. Yes, I'm not trying to sound like that multiple offers are not going on. I would say, though, instead of competing against maybe 40 offers, you might be competing against 10, or the types of offers that are being needed. I'm seeing less like non-refundable earnest money up front, or maybe some contingencies that were being waived are not needing to be waived anymore. So it's the balance that I feel like we're having. I feel like it's moving in the right direction. But like I said, we're still going 300 miles an hour. That isn't going to expect multiple offers. So it's not a slow market by any means that exists. So, you know what, I'm going to probably jump in. I was talking with Jason, and today's topic that we're going to dive into, we are going to share the difference between like our listing agreement and the MLS. But one other thing that I wanted to share with you, which probably is a better segue, deals with a couple of, I'm just going to show you what they're here, just a couple of lawsuits that have been filed with the state. Now, thankfully, they're not filed against us, but that doesn't change the fact of what we are starting to see, and especially with the crazy market that we've dealt with, how important it is that we are really understanding the offers that we're writing, the offers that we're receiving, and making sure that we're covering ourselves so that we can avoid being named in one of these lawsuits, or at least if we ever were, we've got a very strong position to show that we are not at fault. First one, there's both of these lawsuits. I believe there's one that is going to be more credible than the other. There's one, and when talking with Sam Bell, there's two separate law firms that have filed these lawsuits. One is very reputable and credible. That one, it seems the lawsuit, in my opinion, is very simple. And I've been waiting to see one of these lawsuits finally be filed, because I have spoken with other brokers in other companies that have felt that what this lawsuit is filed against is not a breach of contract. What it was, this one specifically, I know you can't see it, but the filing of it is very simple. Earnest money was never turned in. It's a $50,000 earnest money that was agreed to by the buyer and seller. And per the contract, the earnest money, as we've covered this in the past, needing 4 calendar days to receive, and then after receipt, you've got 4 calendar days to deposit it into the broker's trust account. Well, the earnest money was never delivered. And that was it. Earnest money was never delivered. And eventually the offer ended up being canceled. And because the earnest money was never turned in, the seller filed a lawsuit against the buyer for the 50 grand. And it's just very simple. It says that the buyer was in breach of the contract and the seller was damaged. And the seller is seeking not only the 50 grand, but attorney's fees. We've talked about this in the past of where that is a requirement of the contract. And just like any of these other contingencies or conditions, there's an obligation for the parties to follow those requirements. So that particular deadline it exists. And the deadline, like you said, we have to, depending on when we receive the earnest money, tells us when that earnest money must be deposited into the broker's trust account. But those dates do matter. And it'll be interesting to see what the results will be from that lawsuit. And I personally believe that if it doesn't settle out of court, and if it goes the distance, that I personally believe that the courts will find in favor of the plaintiff. And so just be mindful of that one. The second one, now this is one that I believe is going to be much more difficult for the plaintiff to actually win.
Can I ask a question before you move on, Rob?
Yes, please do.
So when we use earnest, that takes time. Is that subject to being in that four-day window of problematic? Or if they've submitted it and it just takes time to go through the system, is that counted as deposit?
Yeah, so again, great question, Lisa. And we don't have any case precedents that we can apply that to, but I have to take that as the same situation as when we get that brought into our office and we make an electronic deposit into our system. You could argue, well, that technically isn't in the bank yet, and it takes time for that to get into the bank's trust account. But yet our paperwork that we show that it was deposited on that date is, we've got the paper trail for that. Earnest is no different. We have the paper trail that it was deposited on that date, and now we're just waiting for the actual funds to post. So I have to believe that it's going to fall under the same decision, or to me, it seems very similar. Did that answer your question?
Yes, sir. Thank you.
Okay. A great question. Any other questions about that? Okay. So this second lawsuit, and it's by a law firm that tends to go fishing for stuff that I believe a lot of the stuff they're looking for settlements. They make accusations on stuff, and in my opinion, this is my opinion, that's solely my opinion, is I believe that they're hoping that they can get some type of a settlement rather than seeing things go the distance. But the second lawsuit deals with non-refundable earnest money. And one thing I'd like to point out is this transaction deals with an offer that it was under contract in August of last year. And it was just filed with the court, I believe, a week or two ago. So here we go, we're almost a year later, and we're now receiving a lawsuit about a transaction done a year ago. Now, the courts allow, I think it's up to 4 years to file a lawsuit. So knowing what's been occurring the last 6 months to a year with these non-refundable earnest monies, waiving contingencies, and this is the reason why our company created that form, to give one more layer of protection. But it takes time to file these lawsuits and determine if they want to file lawsuits. So I personally believe that over the next year or two, we're going to see more of these types of lawsuits filed when clients, when they were desperate to get homes under contract, and they were willing to put non-refundable earnest money. They were willing to waive contingencies, waive their due diligence, not have inspection, just do whatever so that they can get their offer accepted. But then once there's a problem with the home and they try to go to the seller and get it resolved, the seller just basically turns their back on them. The buyer's going to be looking for people to blame, and it's rarely that the buyer or seller is looking at themselves to blame for their decisions. They want to look for somebody else. So this particular lawsuit specifically deals with, it was a $20,000 earnest money. $10,000 of the earnest money became non-refundable after the due diligence deadline. And apparently there's accusations that the buyer communicated with their agent and said that, hey, we're concerned about the financing not meeting that deadline, and we want to make sure that our earnest money is protected no matter what. So we rather cancel the contract than move forward and lose our earnest money. And the accusation is that the agent promised the buyer that they would not lose their earnest money, and the due diligence deadline did pass. And then they approached their financing deadline, and whatever happened, the buyer ultimately had to cancel based on financing, and therefore they lost $10,000 of their $20,000 earnest money because it was after the due diligence deadline. And now the buyer, of course, is coming back after the company and that agent for their $10,000 that they've lost. I since got some additional information that it turns out the buyer gave the lender different information, and that was one of the reasons what caused the loan to fail. They had to bump things around, but regardless, is the buyer is making an accusation and claim against the listing brokerage and listing agent, and it's, as of right now, it's a case that's been filed and nothing has been settled. So whatever happens with that transaction, you know, it remains to be seen. But is it possible that the parties decide to settle instead of go the distance? And it certainly could be, it could be that case. But regardless, is it takes money and to try to defend these things. You know, we have one that we're dealing with where circumstances based on the lawsuit that was filed, E&O denied the claim because the accusation, every E&O policy has certain exclusions. If it, you know, for example, fraud. If you or the company were to commit fraud, well, that's not going to be protected under E&O. That's not what happened in this situation that I'm talking about, that the E&O denied it. But based on one of their exclusions, that's what the lawsuit was filed against. And so there's a situation where E&O denied the claim to even file it. So why I mention this to you, I'm not trying to add additional fear that we already deal with each and every day. I believe that the things that we're talking about are simply, well, they're quite frankly, they're simple mistakes that we as agents have the ability to control. The simple one dealing with earnest money not being being brought in. Now that one is a lawsuit between buyer and seller. So we as agents, let's just say that buyer was my client, and I know that earnest money is due, and I'm reaching out to my client. Hey, Jason, as we talked about it, I need to receive that earnest money within the next 2 days, or else we're going to be in breach of contract. So let's arrange a time that we can that you can deliver that to me or at my office. And Jason says, okay, great. When's that going to be? Great. I can bring it in today at 5. Okay, great. Well, today at 5 o'clock comes and goes, and he never brings it in. Tomorrow I find out that it was never brought in. Hey, Jason, I noticed that you didn't bring in the earnest money yesterday. And we now only have one more day to get that brought into me. Are you going to be able to bring that in today? Yes, I'll bring it in at 3 o'clock today. Okay, great. 3 o'clock comes and goes, nothing. And I reach back out to him. Well, I'll bring it in. Sorry, I'll bring it in at 4:35 today. Jason, today's, by 5 o'clock today, I have got to receive that, or else you're in breach. No problem. I'll have it to him. Well, 5 o'clock comes, nothing. Then I can go ahead and notify our agent or the client, say, Jason, I just need to inform you that as of right now, you're in breach of the contract, and we have an obligation to disclose that to the other side, because that was due by 5 o'clock today. And last 3 days I've been making you aware of it. If the client in that situation, if Jason in that situation doesn't bring in earnest money, that's not on me. I've done everything I can to remind him to make that happen. And I've documented, I've got it in text messages, I've got it in emails to show that our conversation reigns true. So that if we were named into a lawsuit, then we could at least show back and say, hey, this is the reason why we should at least be removed from the lawsuit, because we had nothing to do with this. So on that situation, that one is between buyer and seller. Actually, brokerage is not being named in that. But the other one, dealing with the non-refundable earnest money, that one, the brokerage and the agent is being named. So in that example, what could we have done? Well, when we're writing an offer that says, hey, non-refundable earnest money after due diligence, our company, as you guys all know, and if you don't know, you need to know, is we do have a separate disclosure form. It's the non-refundable earnest money and contingency waiver disclosure that we want our clients to be signing. And in my opinion, I mean, Jeanette just said that she's written 6 offers, shown a lot of properties. Who knows, one of those offers that you might write need to have non-refundable or waiving contingencies. So you may as well have your client sign that at the very beginning when you get the buyer broker sign and say, that just says, hey, this may happen. Our hope is we don't have to do this, but at least want to make you know, understand up front what a non-refundable offer or contingency waiver offer looks like. You have the conversation with them, so then when the time comes, if you need to write one, they now understand what it is. And so we go through that example. Now in this example, hey, Jason, looks like, you know, we're writing this offer. It's where it has half your earnest money going hard, or sorry, I used the word hard. We do not want to use that word. Non-refundable after due diligence. And just want to make sure you understand that. If we go past the due diligence deadline, $10,000 of your earnest money is non-refundable. Do you understand that? Yes. Great. Put it in writing. Now that go back and forth. Just want to make sure you understand that that's what will happen. So now that if an accusation comes later on, no, I didn't understand what this meant. I was never told that I would lose earnest money. I was never this. I was never that. Well, we've got evidence to support that that is actually untrue. So if we were named, then we can at least do it. We can apply for a dismissal of that lawsuit because we've got information to support it. Do those situations make sense?
Yes, I always just include that in my buyer docs now,
Perfect.
just right up front, just so that
Perfect.
they're, and then you have to remind them, of course.
Yeah. And there's no reason for it. I mean, that document just says, hey, if we do this, then you're aware of it. Not saying that any of our offers are going to include it, but it's just more information that they have up front. So that ends up being a good thing.
Hello, hi. I'm new to the office. Where do you get that form that you are talking about?
It'll be located on all of our forms in Dotloop.
Okay.
Under the templates section.
Uh-huh.
When you go in templates you can either just do all forms.
Okay.
And you type in non-refundable or contingency waiver and it'll pull it up.
Oh, contingency waiver. All right. Okay. Thank you.
You bet.
Huh?
Any other questions about that before we go into the next piece of our listing agreement? And I'll take silence as a no. So let's go ahead and I'm going to go ahead and share my screen with you guys. Maybe. Let's see here. Is that the right? Okay, that's the right one. Everyone says concede we're exclusive right to sell listing agreement, right?
Okay. Yeah.
Yes.
Yeah. Okay.
Yeah.
All right. So if I switch on both of these, you guys can see the difference. I've tried to highlight a couple of things that separate our contract versus what's on the MLS. And if I'm switching back and forth like this, you guys are able to see the other listing agreement. Is that correct? Okay. Jason's nodding yes. I'll take
Yes.
that as
Yep.
okay. So this one right here with the highlights on it, this is our listing agreement versus the one on the MLS. So right out of the gate, the first thing that is significantly different from our contract versus what's on the MLS is the effective date of that contract. Our contract right here, it gives a date that identifies when this listing agreement goes into effect. This agreement is entered into in effective the blank day of the blank month of the blank year. So let's say that I wanted to make this listing agreement effective on July 1st. So of course, I'm going to fill that in the first day of July 2022. That's when, so our listing will be effective starting July 1st. Well, I'm meeting with the clients tonight. It's June 28th. And I'm going to be sitting with them tonight. And of course, I want them to sign that. Well, there's no problem. They can initial this. They can sign this contract with today's date. You would make that, they're going to be signing it today, June 28th, but the effective date of our listing is July 1st. So we can't start marketing or doing anything with the contract until July 1st, versus the contract on the MLS. The effective date of this contract is identified in the last paragraph of this. And the ones on the MLS, the buyer broker and the exclusive right to sell, both have this paragraph. So this is one of the key differences between our contract versus the one on the MLS. It says the effective date. The listing agreement is entered into and is effective as of the date the seller and the authorized seller's agent or broker have signed the listing agreement, and the authorized seller's agent or broker has received a mutually signed copy of the listing agreement. Okay, so make sure we understand that. The listing agreement is entered into and is effective on the date that buyer or the seller has signed it and the authorized agent or broker has signed it. I can't tell you how many listings I have seen, and it also goes with the buyer broker, where the client has signed the document, but the agent or it's never been turned in, so I've never even signed it either. And the agent would go to the closing table, and the agent has never signed their own listing agreement, or they've never signed their buyer broker agreement. So just based on that definition alone, there was no effective date of that contract. Okay. But the effective date is whenever they sign it. So if they sign this, if the listing agent doesn't sign it for a week later after the client signs it, but they start marketing and advertising the listing, they're technically advertising that listing without a listing contract. More importantly is, what if the seller were to sign this agreement, again, myself or that listing agent has not signed it down here, and the seller, for whatever reason, decides to list with another brokerage, and they get a contract that is signed by the parties on a specific day, and that agent signs it as well. And so that that listing agreement is signed before ours is. I haven't seen that argued in court or anything, but it brings up a fair argument that just because it was never signed, that the effective date of that contract is now in question. Whereas ours, we define when that agreement actually is effective. Now, that doesn't negate the fact that we too have to sign the agreement to create the contract, but at least we've got an actual effective date that is just defined in the contract right out of the gate. Does that make sense? And then we have another part of the contract that's going to go back to that effective date and explain it. Next piece. Okay. Our contract used to have, if you can see here, if the property goes under contract during the listing period, the expiration date of this contract will automatically extend to the closing date of the purchase contract. That used to be, the MLS used to not have that language in it, but they do now. So that part is no longer different. But we do have this additional piece. How many of you have got a listing agreement signed that trying to think of the example. You get a listing agreement signed, but it also works with when you're working with a buyer, and we've included both sides of this, where we go to sell their house, or they're gonna buy a property, and they decide to buy the lot, but because they plan on building, and you technically need to represent them on the lot purchase. That's the real estate that's being done, but because they're going to build, it ends up being a separate contract that you almost have to establish representation for. This piece, I want to make sure that, yeah, we have it on both. We put this in both our buyer broker and our listing agreement, because we just wanted to give added protection that if a purchase involves both a lot and new construction build, then this agreement will cover both a lot and a build. Now, this particular line is going to apply more for the buyer broker. That's the specific part that it's going to be more viable there. But that is huge when you are dealing with a lot and build purchase. Does that make sense? Okay. Next paragraph. 2 parts. This first part, just the MLS has the word "and." We've got the word "plus." They imply the same thing, but I think the plus is more specific as to what it means. That dollar amount is included with the percentage, and is still the same thing, but I get a lot of confusion sometimes when it's still there. But more importantly than that, we continue to see agents fill out this section of the contract incorrectly. The agent believes, let's just say that the agent is taking the listing agent is taking a 6% listing, and they intend to give 3% of the listing amount as the BAC. So 6% listing, but 3% is being offered as the BAC. We continue to see agents put 3% here, and they may say plus 295, and then they put 3% down here, where it is being defined the amount that's being offered as a BAC. So they got 3% plus 295, and then 3% down here in the bottom of the paragraph. What that agent has just done is they basically are going to sell that house for $295, because this upper portion says the total commission is whatever is here. Of the total commission, whatever percent is put here. So the correct way to fill out this listing agreement should have been 6% plus 295, and then you'd put 3% down here. But when you put 3% plus 295 and 3% here, you've only taken a 3% listing. Does that make sense? Hopefully you guys aren't falling into that trap and making that mistake. If you are, hopefully we've now fixed that problem. Of course, the seller needs to initial this part to make sure that they understand what's being done. Okay. The seller warranties. So this section of this paragraph applies to our effective date on our contract, because remember, our contract, even though they're signing it today, we're going to make it effective for July 1st, or let's just say it was July 15th. Okay, 3 weeks down the road. Well, is it possible that if you push out the date that
I think we lost Rob.
Yeah, I can't hear anything.
Yeah, he's frozen. Just give him a second. He's going to relog in.
it gone from YouTube?
No, it's working. You're just got logged out. He has to reboot, so he'll be right back.
Well, I'm back. It must have been so intriguing that it was so powerful that everything just shut down. Is that kind of what we're getting from this? All right. Sorry about that. Let's see if we can pick it back up where we were. All right. Can everybody see it? Jason, can you see that again?
Yes.
All right. Thank you. Okay. So since the seller acknowledges they've entered into this exclusive right to sell listing agreement with C21 ERS, and this agreement may have an effective date later than the date the seller or sellers sign this agreement. In the event the effective date of the ERS is later than the date this ERS was signed, the seller agrees they will not enter into another ERS agreement with any other brokerage. If the seller do enter into another agreement, this ERS shall govern. So let's make sure we understand that. So again, seller signs the contract tonight, the 28th. We're going to make this contract effective on July 15th. That's when July 15th is when we can put it on the MLS. We can start marketing the property. But for 3 weeks, they're getting the property ready to be, to get photos taken or whatever it is. But now we've said, hey, seller, even though this contract is not effective until July 15th, you can't enter into any other agreement. Does that make sense? That's a big deal. So now it gives you that protection to get your contract signed tonight. And whenever they want to put it on the MLS, great. We can certainly do that. Okay. One more piece of this paragraph that is huge is if the seller is telling us there's something wrong with the property, seller will be required to notify the listing agent and the company in writing of any defects in the property known to seller that materially affect the value of the property. If this notification is not provided in writing to the listing agent or the company, it's as if the notification did not occur. Mean by that? What if the seller were to tell you, hey, Jason, just so you know, there's a hole in the roof. The seller claims they told Jason that there's a hole in the roof and Jason doesn't recall that it happened. And now the seller goes to the buyer is going after the seller because turns to be a hole in the roof. And the seller's saying, hey, I told Jason that was there, so they should have disclosed that to the buyer. Well, if in fact the seller did tell that to Jason, yes, Jason would be obligated to make sure that disclosure occurred. But this section here is to avoid any, you can say, dishonesty. Because the seller, in their own property disclosures, they should be making that disclosure themselves. We don't want it to be a he said, she said type situation where the seller's making a claim that they have told us about something and we believe that didn't happen. Well, now we're also going one step further that says, hey, seller, if there is a material fact, you've got to disclose it to us in writing for it to be effective. Otherwise, it's as if it didn't happen. So again, one more layer of protection for you. Okay.
Rod,
Yeah.
I have a question. Just
Sure.
on the ERS, when we go and have it signed with the effective date, if the multiple listing input form, the seller's disclosures are not signed on that very day, is it fine as long as they're signed prior to the effective date?
So is your question asking what's the latest date the seller's disclosures need to be signed?
That and the MLS, just want to clarify that it all doesn't have to be signed on the very same day. Yes, so I guess that is the question I'm asking. As long as they're signed prior to the effective date, is that fine?
Well, the seller's disclosures, actually the seller disclosure need to be signed technically before they are due to be given to the buyer.
Okay, so sure.
But we're going to do this. Hold on to that question. Because as we get to the end of this contract, there's going to be one more piece of the complete listing contract that's going to answer your question. And so if I don't answer it, bring it up then. But I think we'll cover that shortly.
Thank you.
Okay, you bet. All right. Professional advice. Now, this paragraph is actually the same as what's on theirs, but we've just gone the extra step to make sections of this paragraph bolded. Again, from a legal perspective, I've been told that when you make distinctions, whether capitalizing things or bolding things, it is one extra layer of protection that you have tried to make this information stand out for the buyer and or buyer or seller, and B, the client, it's harder for them to defend that they didn't see it or they didn't notice this. So because the courts can say, you're telling me that in this paragraph where this section specifically is either bold or capitalized, it stands out even that much more that you still didn't recognize it. Well, client, shame on you. This is your fault. So bottom line is, seller is advised not to rely on the company or any of its agents of the company for a determination regarding the physical or legal condition of the property. That is not why they are hiring us. And when we as agents start crossing over to that side of the job, well, that's not what we are hired to do. So we as the agents are not hired to do, even if you are a general contractor, that is not why you were hired to sell their house. You're hired to sell their house, to market and expose and find a willing and able buyer. Your general contractor license, that hat has to come off. And if they want to hire you for work on the home, well, that might be a conflict of interest for our company, but it needs to be very clear, worst case scenario, that you are being hired for a separate job, it has nothing to do with selling that house. Okay. So, all right. Advertising. So this paragraph is basically the same up until, except we have two additional pieces that are part of our contract. One, when the property is pending under contract, seller instructs the seller's agent to not present any additional offers unless the offer is designated as a backup offer. All additional offers will be presented if instructed in writing by the seller. So your licensure requires with the state that we must present all offers that we receive to the seller, unless in writing the seller instructs us to do otherwise. That's what we're taking care of right here. This is now being done in writing, that once we're under contract, the seller is instructing us not to present any additional offers unless they're in a backup position. We can present those. So there's our requirement that we're fulfilling within the division. In addition, in the event the buyer's agent requests to present an offer in person to the seller, this, for those of you that some of us, and Lisa's been in the business for a while, we used to do this all the time many years ago. This was the standard approach of presenting offers. The buyer would be the buyer's agent would be in the house of the seller with the listing agent present, and they're presenting their offer in person to the seller. So if a buyer's agent were to request that they still wanted to do that, we've already got authorization from the seller that we're not going to allow that to be done. So again, an added piece that our contract benefits us versus using the one that's on the MLS. Okay. FERPTA. They say basically the exact same thing, or it's talking about the same thing, but we've gone just more in depth. So the paragraph here gets more specific of what sections of the area that are being involved or not. It even talks about how much everyone understands what FERPTA is, at least if you don't. I guess please let me know right now. And that's another category, another section we talk about it. But what the amount could be responsible for the buyer, we put that in our section versus what's on the MLS. the bottom line is this, and this part is the same. You are not expected to explain to the client what FERPTA is. If they have questions about whether or not they are a foreign individual, they need to contact their own accountant, contact their own, whoever they need to understand whether or not they're considered a foreign entity or not. Okay. Next paragraph, nothing too extreme. We just added under the electronic piece that electronic signatures also count towards electronic documents being signed versus just saying email or fax. And then these last two sections. Okay, Galen, I think this goes back to what your question was, is what the entire agreement means. So your question is, does the data form need to be signed on the same day as the listing contract? Well,
Correct. Yeah.
yeah, so the listing contract, if we get that signed at that moment, I'm going to say the best answer is yes, because very similar to the it's the exact same language that's on the MLS, that this entire agreement includes the following. The listing agreement includes the seller property conditions form. It's part of the listing agreement. The data form, wire fraud disclosure, and any additional addenda that are part of this. Now, that doesn't mean that that's the total listing agreement. So can you get the listing agreement signed today and the data form signed tomorrow after they fill it in? Yes, you certainly can do that. However, I still think it's the best practice, and it should not be very difficult to get both of them signed at the same time. And how you accomplish that is in advance. When you go on the MLS and create these forms, if you believe, when I went on appointment, I have the majority of this filled out anyway, because when I do my pre-qual with the seller, I'm asking them how many bedrooms and bathrooms, how much of the house is completed, how much is what's updated, what's not. And then the things that I have to fill out specifically after I look at it, I can do that in advance when I'm right there in front of them. But the majority of the data that's on the form is already filled out. So if we do our job, I guess is where I'm going with it, Galen, is it seems to me that it would be odd that we can't get that signed at the same time we get the listing agreement signed.
Okay, great. Thank you. I think the part I was curious about was like the remarks when you're, doing the remarks describing the property, but by all means, it can all be done ahead of time. So thank you for clarifying that.
Yeah, and even when you're doing those remarks I agree, you put some thought into it. You can certainly have the majority of that filled out, and then when you're there with the client, hey, let's finish I've done the rough edge or the beginning part of these remarks. Let's finish them right now together. And now
Awesome.
they're part of it, and it's done.
Thank you so much.
Hey, no problem. Hopefully that makes sense for both of those. It's kind of a two-part meeting today, but any thoughts, any questions about that?
I have a quick question, Rob.
Yeah.
With those forms, if you get them pre-signed, are we doing an office exclusive also with that? And then filing that with the MLS?
Oh, you're talking about a notice of exclusive listing?
Correct.
Okay, yeah, that would not be needed because the notice of exclusive listing says that you're taking the listing today and you're not going to put it on the MLS for 2 or 3 weeks. All we're doing on our contract is saying, hey, we're signing the listing today, but it's not effective for 3 weeks.
Okay, so that's the difference. Okay,
that's the difference.
perfect.
Can I ask a question with regards to that too?
Sure,
I
yes.
had a listing in the past, but we wanted to market in-house like a week before, so we could talk about it. So I did send in, my listing didn't go live. We had it dated a certain date, but I did send it in to the MLS that we'd be doing an in-house prior to that. So I did do that. Was that the correct way to do it?
Yeah, Chris, and that's the other way that this could be done. You certainly could do that. You could take the listing. So I go and sign it tonight. I sign it on the 28th. Let's say that they are just doing repairs or whatever, but your client does want to be able to market it to our agents. That's not publicly marketing. You can't put it on the MLS. You can't do all this outside Facebook posts, but internally to our company, you could be saying, yes, I've got a listing here. We're doing some work on the property, but yes, we have taken a listing. If you're doing that, then yes, Chris, you would have to get the notice of exclusive listing form signed and turn that into the MLS. So now come July 15th, if that's when you're going to put it on the MLS, you won't be fined for that 2 or 3 week delay of uploading it.
Perfect. Thank you. Hey, can we also get a copy of the highlighted exclusive right to sell that you were just showing us?
Sure. Yeah, I can email that out.
Perfect. Thank you.
Yeah. Any other questions?
So do we need to email you requesting the copy of the forms that you highlight?
If you'd send me an email, because I mean, I don't know all the parties that are on this call. Yes, if you're interested in having a copy of that that highlighted version, then yes, please email me. And it's just rob@c21everest.com. Just email me and I would be happy to send a copy of that to you.
Thank you.
You bet. Anything else?
Nope.
Okay, everybody. Thank you so much. Enjoy the
Thanks,
rest
Rob.
of your Tuesday.
Thank you.
And we will talk to you later.
Thanks.
Bye-bye.
Bye.